Hello. Sorry I'm late. I shouldn't be lagging on my end, but I was before. That's why I had to restart StreamYard. Let me know if you guys can see me and hear me. Hello, hello. We are back with the Kelsey Fitzsimmons tonight. We're gonna go over a short document and then we're going to watch a little bit of a hearing. Um, so thank you for being here. This case is very important. It is out of Massachusetts, aka the same place Karen Reed happened. Thank you for being here. Let's see. I see Evie, Debbie, Green Eyes, Crease. Hey, hey. I saw who else did I see in here? I think I missed someone. And Robert. Hello, hello, Robert. Oh, and Abuelita. Hi, Abuelita. Good to see you. Okay, let's recap because I know I haven't talked about Kelsey in a minute. So she is a North Andover police officer. She was going through postpartum depression and she had been dealing with it when there was an incident where she was involved with a firearm at her home when she was being served a restraining order by her fiance at the time, Justin. So she ends up pulling the firearm. She was gonna basically unalive herself, but she ends up pulling that firearm, and the officer, her co-worker, co-partner, whatever, was in the room, and he's also obviously an officer, and he thought that she was going to shoot him, so he shot her, pretty much. And she was in the hospital for a while, had to get a lot of surgeries. Um, Her fiance filed a restraining order against her and did all of this shady stuff without her even knowing any of this. So I think this case, as much as it is about corruption, I think it also we should be more zoned in on, I think, the familial aspect of it, but I know that would be complicated. So prosecutors say that Kelsey was pointing a firearm at the responding officers who were serving her a restraining order, but that restraining order stemmed from accusations of her fiance. And her fiance went and got this restraining order. She didn't know anything about it. And then he basically filed to get full custody of her newborn baby, which she hasn't seen since he was 4 months. And I believe he's a little bit over a year now. She was in jail for a while. They wouldn't budge because allegedly something with her ankle monitor. Like she didn't breathe in fast enough. It was a mess. We do have a playlist on that. Her attorneys dispute the allegation that she pointed the gun at the officers because, like I said, she was going to unalive herself. Like I said, she was in jail. She was released recently. Um, Trial is set to start in March, mid March. So I probably will try to cover that. Um, and now there's this new situation that has happened as of recent. So her fiance, who did all of this, he in the recent court documents that have been released, ended up it comes out to be that he broke into her house. So while she was in the hospital, she he broke into her house and tried to change all of her accounts, bank accounts. All he did all of this crazy stuff, and there's video of it that has just been released, and he's not being charged with anything. So they're not going to charge him for breaking into her house and trying to break into all of her accounts. He was trying to change stuff. So they're not going to file charges against him, which is crazy. There's a short clip, so we're gonna watch that as well. I'm trying to think what else I'm missing. Let me look at my notes. Um, they break into her home on July 3rd of 2025 while she was hospitalized. So cash, electronics, passport, and personal items, they were taken, and the laptop, Kelsey's laptop, was used to access her accounts and withdraw funds. Um, Her defense claims prosecutors have not filed related criminal charges against the fiance, despite the evidence suggesting potential bias and conflict of interest. So it's not nothing new. We've seen this with the Karen Reed case. What I don't know what is up with all the law enforcement there and the district attorneys. I have no idea why he's not being charged, and it should open the door for him to be investigated and looked into. Because if he just filed that restraining order as retaliation to her for whatever they were going through in their personal relationship, she shouldn't have been charged and have gone through everything she went through. And she's still trying to heal from postpartum depression, and she still doesn't have her baby. So it's pretty controversial. I'm going to pull up the document so we can get right into it. We're going to read the document. We'll watch the clip of him breaking in. We'll watch the most recent hearing. And then I think that'll be the update as of everything. I'm trying to stay on top of it. I haven't done any updates on it because there wasn't much. I think she was just waiting to go to court, and then she got out on bail, and she's been trying to, yep, I remember. Yeah. It's a very sad case. It's a very sad case. I think that she was dealing with postpartum. I think they should change her restrictions on seeing her baby. And I think he needs to be arrested for breaking into her house, like while she's at the hospital. And he tries to get into like all of her accounts. And we have the exhibits. So we'll look at those. So here's a document. It's only a couple pages. And it states, now comes the defendant, Kelsey Fitzsimmons. Okay. I'll skip. Oh, his name is Justin. Yes. I'm going to skip through all the court stuff. The Commonwealth's obligation extends not merely to formal immunity agreements, but to any promises of non-prosecution, unilateral forbearance from prosecution. So he was offered immunity from prosecution. Offers of favorable treatments or requests for such treatment that could reasonably affect a witness's credibility, bias, or motive to just testify. A jury is entitled to know whether a witness avoided prosecution, received employment protection, financial benefit, or other favorable treatment in circumstances where criminal or disciplinary exposure exists. Here, the Commonwealth claims no such inducements exist, but the circumstances and the weight of the evidence strongly points otherwise. The Commonwealth's blind eye is purposeful, brazen, tactical maneuver designed to avoid the total implosion of its case against Miss Fitzsimmons, the true victim here. Why are they ignoring that he broke into her house and did all of this as he was setting her up for a restraining order? It's outrageous. The court should enter orders to ensure that full disclosure is made. The defense makes a specific request for discovery as to each of these referenced witnesses. Oh, sorry, I jumped. This is ridiculous. I believe he's a firefighter too. Her ex-fiance. Justin Layan, non-prosecution despite overwhelming evidence of criminal activity. On July 3rd, 2025, while Ms. Fitzsimmons was hospitalized at Mass General Hospital, fighting for her life after being shot in the chest at the time, as set forth on video surveillance, Justin forcibly broke into her residence with 3 other accomplices. Justin had 4 days prior obtained a fraudulent ex parte family court restraining order from an affidavit full of lies about Ms. Fitzsimmons stealing custody of their 4-month-old child and receiving an order that she stay away from him and the baby. In the affidavit, he swore that he lived with his parents in Stowe, Massachusetts. Given the order in his favor against Kelsey, his adversarial position and litigation against her and her sole ownership and residence in the premises, Justin had no residential or possessory rights whatsoever regarding Kelsey's secure locked property. He had no business going there and no right to enter. In fact, Ms. Fitzsimmons' father, an alarm and surveillance contractor, had just changed the locks and updated the surveillance system in the house after Justin's surprise litigation against his daughter. This is ridiculous that he is not being charged for this. Like, what? He had no business going there. As detailed in if he was allowed to be there, quote unquote allowed, why why would he break in? You know what I mean? As detailed in Kelsey's sworn statement, see Exhibit 2, and corroborated by Stephen, oh, her dad, Stephen. Oh, shoot. Um, this is what happened. Justin broke the front door and door jamb to gain entry. He entered with 3 other individuals. So he brought his friends. The surveillance system and alarm were immediately disabled and destroyed, causing thousands of dollars in damage. The modem power was forcibly pulled out of its wiring. Justin stole cash, gift cards, Kelsey's passport, her personal laptop computer, and other valuables. Justin stole evidence contradicting his family court affidavit, a handwritten letter authored by Justin praising Kelsey as an amazing mother, removed from the refrigerator to prevent its use exposing his lies about her. Further, after stealing Ms. Fitzsimmons' laptop, Justin brought it to his parents' residence in Stowe, Massachusetts, where it connected to the family's Wi-Fi network called Braceland 4. From there, he accessed her Facebook, AOL, and Gmail accounts, gained entry to bank accounts, withdrew approximately $5,000, closed accounts, accessed her medical records, accessed her pension beneficiary documents, and canceled her travel reservations, redirecting funds to his own account. All of these actions were traced and readily apparent on the laptop's recorded computer history. The laptop was returned. Oh, sorry. To the home at some point in Kelsey's 53-day hospitalization and what had to have been another unlawful entry, an obvious effort to conceal the computer crimes. Wow. So he goes in there with his homies, breaks in, takes her stuff because he wants to set her up to get this restraining order so he can have full custody of the baby. And meanwhile, she's fighting for her life after trying to commit suicide due to postpartum depression, is being basically imprisoned for it. And he goes back and drops it off while she's in the hospital for almost 2 months. She was in the hospital for 53 days. $5,000 is a lot, and the fact that he got into her emails and everything, that's ridiculous. Hey, Kat Randall, good to see you. That is so. Everyone there should be outraged. He should be getting arrested. If he doesn't, then everyone else should get a pass as well. Immunity for what? To testify against her for what? For things that he set her up on? I absolutely believe this. So it says the conduct described constitutes probable cause for at minimum. Breaking and entering with intent to commit a felony. Destruction or concealment of evidence. Malicious destruction of property. Unauthorized access to a computer system, and identity fraud. Despite requests for investigation, sworn statements, cooperation, and video evidence, the Essex County District Attorney Office has declined to charge Justin with any offense arising from July 3rd, 2025 incident. No agreements, emails, texts, or other writings have been provided relative to the non-prosecution. Further requests that the matter be referred to outside prosecutor due to the obvious conflicts that have been rebuffed. Wow. Wow, 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 wow. I'm outraged. If you're into the Karen Reed case, you can probably connect the dots, but like, what the actual fuck? This extraordinary leniency in multiple felony case involving destruction of potential evidence in a pending criminal matter constitutes a considerable benefit. Whether characterized as prosecutorial discretion or declination, the practical effect is the same. Justin avoided significant felony exposure. It strains credulity that there is no discoverable information surrounding this complete abdication of prosecutorial responsibility in favor of a witness adversarial to the defense. The Commonwealth must be ordered to provide or memorialize any verbal or written discussions, assurances, understandings, or implicit agreements or positions regarding the reasoning or cause of non-prosecution. A jury is entitled to know whether a key witness stands in a position of gratitude, vulnerability, or expectation of continued protection. Officer Patrick McCarthy Noonan, non-prosecution, employment protections, and financial benefits. Patrick McCarthy Noonan shot Ms. Fitzsimmons in the chest on June 30th. The events are not recorded by police body cam or residential security cameras. They also don't have any body cam. Like, excuse me? You're corrupt, setting her up, and you don't have body cam. So you want to charge her. He claimed Ms. Fitzsimmons tried to shoot him without ever interviewing Kelsey. The prosecution believed and adopted Noonan's fanciful, self-serving version of events. The Commonwealth sought to leverage the shocking allegation into assault with intent to murder, which is a 20-year felony, which was rejected and no-billed by a grand jury in favor of an entry-level superior court charge, assault by means of a dangerous weapon. In these circumstances, a 1-year probation disposition is eligible under the sentencing guidelines. The allegation that Kelsey assaulted Noonan hangs by a thread held only by Noonan himself. As a result, the Commonwealth is strongly obliged to make him as comfortable as possible. After shooting his colleague, he was immediately placed on quote-unquote critical incident leave from June 30th through August 27th. Upon returning to work, Officer Noonan resumed full-time duties and worked paid details. For approximately 38 days, this was a status quo. On or about January 11th, 2026, Officer Noonan failed to report for his scheduled shift and was deemed AWOL. What? Officers responded to his residence for a well-being check after phone calls went unanswered. Officer Noonan eventually answered the door and stated he had taken a Flexeril and did not wake up for work. Despite this, he received only a written reprimand. He was placed back on critical incident leave effective January 17th, 2026. He has continued to be permitted to work paid detail assignments while on leave. Critical incident leave is ordinarily reserved for officers unable to perform duties due to trauma. Officers placed on critical incident leave are typically removed from active duty because they're not considered fit to perform the full responsibilities of a police officer. To defense's counsel knowledge, working paid details while on such leave is highly uncommon, if not unprecedented. In fact, North Andover Police Department's collective bargaining agreement states, quote unquote, a patrol officer on limited light duty shall not be eligible for details or overtime. The continuation of paid employment benefits following an AWOL incident arises serious questions regarding preferential treatment and whether employment protections are tied directly or indirectly to the Officer Noonan's role in this prosecution. The details of this extraordinary arrangement are crucial to the defense. Paid leave, deferred discipline, employment protection, or internal agreements regarding discipline are tangible benefits if any favorable treatment was extended in connection with his cooperation or testimony. It is impeachment evidence that must be disclosed. Yo, she's a cop, where's her union rep? This is crazy, you guys. They're trying to lock her up. Lock her up. Judge siding with other cops is wrong. Maybe there's some lack of proof. They just said they don't even want to charge him with any of this. Legal standard. Unlike Brady and Giglio, the Commonwealth must disclose any evidence favorable to the accused that is material to guilt or punishment, including impeachment evidence. Mass courts have repeatedly held that promises, inducements, understandings, and favorable treatment must be disclosed. These are basic axiomatic discovery obligations. The legal duty is affirmative and continuing. It is not satisfied by silence or by the Commonwealth's unilateral determination that information lacks materiality. When witnesses avoid prosecution, retain employment, receive paid leave, or benefit from discretionary leniency in the shadow of criminal or disciplinary exposure, the jury is entitled to assess whether that treatment influences credibility. Yeah, it does. He broke into her house while she was at the hospital. And now is claiming she's an unfit mother, and so she lost custody of her newborn baby while dealing with postpartum depression. He was her fiancé, but I wish maybe she was over his shit. The defense requires the details of these arrangements, and the Commonwealth has not provided one shred of documentation. And then here's the exhibits. Oh, the Wi-Fi. Look at all the times he tried to log into her accounts. Sign into AOL, Facebook, forgot password, reset password, how to get into Facebook with the forgotten password. This is like he did all of this on her laptop. Facebook, can't log into Facebook, can't log into Facebook. What a shady ass. Facebook challenge, reset your Facebook if you can't access. He stole her computer and passport. Yeah, he stole her whole ass computer, you guys. This is stuff my ex would do. It's a little bit crazy, I'm not gonna lie. Take that how you want. Respectfully. Like, this is crazy. No, what's crazy is like, okay, one thing is being in a toxic relationship. Another thing is like setting her up, trying to send her to prison. So he's trying to get into this is all exhibits too. He even transferred himself 5 grand. By the way, you guys, the house was hers too. He had like nothing to do with it. She bought it all on her own. And then still takes her baby and is also trying to take her house. Release clinical information. He got her medical records. Like, what? Your 360 performance savings account is closed. Meanwhile, she's literally fighting for her life at the hospital, getting surgeries. Like, it's absolutely insane. This is corruption at its finest, and we saw it with this in the same state with Karen Reed. Like, corruption runs deep there. It's absolutely outrageous. This is the second female that gets set up like this in mass. Medical records request, ambulance report, date of birth authorization, medical records release. Yo. Let's watch the clip now of him breaking into her house. This is crazy. How would you feel like imagine your baby mama or baby daddy does this. You go to jail for it. By the way, they don't even really look into it. There's no body cams, by the way. So no one really actually knows what happened except all of them. And you know what? Why would Kelsey try to shoot her partner? Like, what does she get out of that? I believe she was actually trying to take her own life. We're going over Lindsay Clancy case as well here on my channel, and she was dealing with postpartum as well. Like, I believe she tried to take her own life. I really do. I really do. Let's watch this video. I'm going to show you guys a picture of them first, actually. And then we'll watch. It's a 1-minute clip of them breaking in. But I mean, look at them right here. Like, what? Like, what? How sad. She hasn't seen her baby since her baby's been 4 months. It's really so sad. I don't know who this person is. Carry true crime. The only reason someone would disable surveillance cameras inside of a home they don't live at is because they're about to do something they don't want to be seen. And they're trying, and he's basically saying that she's unstable. She's the unstable one. Yeah, maybe. He's unstable too, though. Like, what? She was way out of his league. Absolutely. He's a firefighter, and I think she's an officer. Wait, is he a firefighter or is he a cop too? Ooh, no, he's a firefighter. I'm pretty sure. Um, she already did time too. How much time did she do? Let me see. I'm curious because that's crazy. She was in jail for more than 100 days without bail because she failed to breathe into her alcohol monitor, which why does she have an alcohol monitor? It's not like she got a DUI. Like, what we already had this conversation on the previous lives, but that's one thing I'm questioned about. And she couldn't breathe into it or blow into it because she had just had she got shot in the chest. This is crazy. This is a crazy case. And it should be important to everyone because that's a corruption and it could happen to anyone. Okay, let's watch this 1-minute clip of him breaking into her house. Ugh, I'm disgusted. I'm disgusted. Okay, here we go. Um, arrest his fucking friends too. Excuse me? Excuse me. Wow. Wow. I'd be pissed. I'd be pissed. Wow. You guys, and they're not charging him for anything. They're saying that what he did was okay. No. No, it's almost a joke. Like, I think like, "Ha, it's not April Fool's yet." He stole cash gift cards. Sorry, I'm reading the report on the screen. Cash gift cards, her passport, computer, and transferred $5,000 of himself. And he's trying to take her house, which she paid for. And he took her baby. And he's basically claiming that she's the crazy one. She's the crazy one. That is so effed up. That is so effed up. And to bring your dirty little friends to break into her house. Oh, big boy couldn't do it all by himself, huh? Yeah, that's what I thought. Like, it's disgraceful. Thank you. Oh, yeah, you both said it at the same time. So disgraceful. Shady. Grand theft. They claim no jurisdiction to bring charges. What? That's outrageous. That is absolutely outrageous. Although that restraining order needs to be lifted and she needs to be given her baby back. And if not, then he shouldn't have the rights to that baby either. Like, this does place credibility issues. That's freaking ridiculous. Let's watch a hearing. It's not very long, but let's watch that. And that's pretty much the update. So I will probably most likely be covering Kelsey Fitzsimmons. I don't know how long. How long is this trial even supposed to be? Let me see. I imagine it wouldn't be that long, but has not been publicly released. March 23rd. And that's for the weapon charge. Wow. Mark. Oh yeah, I'd be nervous he would do something more serious. So, okay, she's gonna have trial for the weapons charge, but like, what about him being charged? Like, how can they prove that she didn't try to shoot him or did her coworker when there's no body cam? I think they need to just drop the case and consider it whatever the fuck they do. Like, it was an accident. Something like that. And she needs to get her baby back. They were fiancés too. Like, what? Dang. Okay, let's watch this for a little bit. This is the hearing. That was this week. Oh.
And that's my agenda. I don't know if you folks had other things that you were anticipating or wanted to raise. Anything? No? Did I miss anything?
No, I think you covered it.
All right.
I do have a few things.
Sure.
So we have a long list of things that we consider to be outstanding discovery. So I think we have a Rule 14 issue, and council and I have been going back and forth on it, but I don't think that there's been enough digging, frankly, about some of the stuff we're looking for.
All right, so I'll tell you what, so that will be part of our discovery agenda. All right, we'll do that. I'm not cutting you off. I'm just trying to get an idea of what lays ahead. But yes, I do want to get out in front of the anticipated discovery issues, including the motions that were filed. But,
sure. And Judge, on that bail motion, I certainly want to give the Commonwealth time to look at it and react.
On the what?
The bail motion that I requested.
I saw something. I have not read it. I don't know if Mr. 𝗝𝗲𝗍𝗆 shared. I had a charge conference this morning in a trial that's been before me for 5 weeks. It's going to the jury on Monday, and I just haven't had time.
Sure.
So if there was something filed this morning, I didn't see it.
Sure.
Outstanding discovery can be addressed with a motion to compel.
Talk about that, but you said it's bail related?
It is, Judge. It just, whenever you're ready to address it, but there's just some pressing aspects of her terms of release that are really hindering our trial prep.
Okay, well, I think, so I'll tell you this, I have read the materials that are in the file. I don't know anything else about the case other than what's in the file. But my memory is that, wasn't there a 58A order?
Yes, Your Honor.
And so if there's any changes that need to be made to that order, I believe the law requires it to go before the judge that imposed the conditions. Is the defendant out on conditions of release?
She is, Your Honor. That's correct.
Okay. So, yeah, I mean,
So that's going to trigger a recusal hearing, Your Honor. We have a request for an evidentiary hearing that Judge Ricciuti, the Chief Justice of the Superior Court, took over, and he ruled that my motion to recuse the prior judge was moot because.
So she got a new judge.
She was not going to, essentially, because she was not going to be around in the sessions. So this is a,
Let me first get this that you're talking about.
Sure.
Mr. Roy, let me get the motion. So this is paper 54, defendant's renewed motion for bail determination under section 5787 or chapter 276. So you say,
so we're asking for a revised bail determination. That's correct, Your Honor.
okay, yeah, in other words, a change in the conditions of release or something?
Yes, that's correct. The document 51 in the docket, Your Honor, is our just filed.
This shouldn't even be an issue. The whole breathing in or blowing into the device was a medical issue she had. And there's doctors that proved that. She didn't even have to be worried about this right now. That's what's crazy.
The prior substantive motion we filed was a motion to recuse Judge 𝗵𝗏𝗍𝗍 from the case.
Okay. So let me first see if there's even an issue. So
Sure.
Mr. 𝗏𝗏𝗍𝗍, you presumably have seen this motion?
Yes, I got it late this morning.
All right. Leaving aside whether today is the appropriate time for it to be heard or not, what is the Commonwealth's position is? Should it be heard by Judge McCarthy or?
Well, yes. At the end of the day, there was a number of hearings in front of Judge McCarthy. The defendant appealed her decision to the SJC. The SJC denied the appeal, saying she did not abuse her discretion. That's where it stands now. Defense counsel did file a motion to recuse.
I'm so mad about this case.
Judge McCarthy,
Like, wow.
as counsel said, can't remember the name of the judge.
Richard.
And also her job took her back too. Like after she went on leave for postpartum depression, she went to therapy and all this stuff. And then she actually went back to work too. So they can't even lie and say that, oh, we thought she was shady and still going through shit. Like she was stable enough to be back to getting paid by them. No body cams. It's he said, she said. Then her ex surprisingly serves her with a restraining order that same day. So like that's why this whole thing happened. She was at home with her newborn baby, and I'll show you guys a video after this. And her coworkers came and gave her a restraining order, took her baby, and that's when she was like, I can't do this anymore. And then that whole thing with her coworker happened. And then she's healing in the hospital for 53 days. She can't breathe into the alcohol monitor, which I'm still shocked. Like, why was it? What does the alcohol have to do with this? Like, it's not like she got caught drunk and shot him. Like, she wasn't under the influence. I'm really like surprised. You would think they would implement something like a mandatory therapy or like something, but why? I don't get the whole like the alcohol monitor, because I've had one before, and trust me, it has to be a alcohol related crime. So it's almost like I'm a little confused about that part. But anyways, so she can't blow into it because she just had surgery. She got shot in the chest. So then they take her to jail. Then they don't give her bond for a while, and then she finally gets bond. And then this all comes out that her ex went into her accounts and broke into her house and all this stuff. Basically, they're setting her up.
Yes.
They set her up. They set her up. With the case of the firearms, and her ex set her up personally without restraining order. Took advantage that she was out for 53 days fighting for her life to take her baby from her and prove that she was unstable.
Because he asked her to get off the case, not anything else, just to get off the case.
That's
what
sad.
the defense counsel was asking for.
And then that's the person she was going to marry. Like, imagine that. Imagine the disappointment. This is a Twilight Zone of mass. Yeah, I have a playlist on this. You guys should watch it and get caught up. I think I've only had like 3 videos on it too. There's not a lot that's been going on. Like, she was denied bail, and then this has just now come out as of the recent week. So you can definitely get caught up, because I'm definitely going to stream the trial. I don't imagine it would be that long for this case. because it's just a firearm dispute. They're not disputing what he should be charged with or that restraining order. So I don't imagine it would be very long. Postpartum, it's beyond mental or medical. Yeah, she has been and continues to be targeted. I agree. 𝗠𝗲𝗺𝗀𝗆𝗆? Yeah, I will absolutely be doing 𝗠𝗲𝗺𝗆𝗆𝗆. Or you mean Corey tonight? Corey tonight? Yeah. Why hasn't she gone on TV to talk? She has. She's just now doing it. A lot of actual YouTubers that are into the Karen Reed case have been doing like fundraisers for her and stuff. And like, I should maybe get involved in that. That would be fun and that'd be good. She dodged a bullet not marrying that dude. He was punching way above his weight. I think so too, Lakeside. I don't know what she saw in him. I feel bad for her.
Because she wasn't in the trial session, she wasn't going to be the trial judge, so none of that was acted upon. And so,
someone using your mental health issues against you is not cool. It's not a good feeling. It's not easy to deal with.
But there's been an extensive history that the judge has dealt with, and frankly, I don't see a change in circumstances anyway. So.
Well, let me ask.
I would point to document 51 for a change in circumstances, Your Honor, about the true nature of what's been going on in this case.
Okay, so let me say this. I like to have practical results and be pragmatic as pragmatic as the rules and the law allow me to. So I don't. Is it something that you would object to me hearing or something?
Dude, that could be anybody. Literally, you're right. Anyone, Evie. Anyone. Someone needs to help her. Her lawyer is Turtle Boy's lawyer too, I believe. So I think she has a decent lawyer.
No, if I have the legal authority, if you folks agree that I have the legal authority to weigh in on it, I don't know that today would be the appropriate day to do it or not, but we can talk about that.
I appreciate you being open to that, Judge, and I can narrow it, in terms of what I want to impose a little bit on the court and on counsel today to deal with is, some of these terms are duplicative and they're just bureaucratic. They're just onerous. And, 48 hours notice to make an appointment to come to my office. I don't know when I'm going to be in my office within 48 hours, and I need to have Ms. Fitzsimmons more when I need her to prep. And so the idea of giving 48 hours notice to probation, to leave house arrest, to come to my office in Boston is just extremely onerous. Also, she's in the custody.
Let me just, because there's a couple different issues. One is whether, because I don't want to waste your time if it, in the sense that if it's something that does need to go to Judge McCarthy. So I guess what is the Commonwealth's position? Presumably the defense position is that I can hear it.
Yes.
And I should hear it.
You should. Well, our position is that she should be recused. We're more than willing, ready, willing, able, and happy to have an evidentiary hearing on it. I don't think the Superior Court wants that on her recusal. And we think that the entire framework of this case has been an absolute circus from the beginning. And I'm glad you're here, frankly. And
Whatever.
I have a pending motion to recuse. Well, not pending, but I filed a motion to recuse, Judge. And I am very unhappy with the way this thing has unfolded since arraignment. And we have moved to recuse. Judge Ricciuti, I think wisely, has made it a non-issue. And I want to forge ahead with Your Honor. And I want to go ahead with the case on all aspects with Your Honor. And I don't think it's in the Superior Court's best interest. I don't think it's in Kelsey's best interest. I don't think it's in anybody's best interest to kick this back to where it just came out of. And I just want to ask for a few things today. And I know that, the court can say no, you got to wait. The Commonwealth can say no, you got to wait. But I think these things are not unreasonable. I just want to get rid of the 48-hour notice. I want her to be able to come to my office, get in a car and drive there on her own.
How is she a danger to herself? She can't even she needs permission to see her lawyer because she's on house arrest for not breathing into the alcohol monitor. Question mark, question mark. Like, what was the alcohol monitor even for, sir? Like, was she drunk at the time of the incident? No. Was she drunk maybe when they had fights before in a personal relationship? Okay, so what? People do that shit all the time, drunk or not. Like, people fight, toxic relationships happen. It's a true fucking thing. Like
a grown up. Her mom is the custodian of Miss Fitzsimmons. Her mom works full time. This has been an incredible hardship on her. She's got to drive her to my office and sit around for 3 hours. Really unfair.
Let's do this. Let's do this. Before we end today, we will address whether I will address it or not. And the reason why is because I like to read it. When attorneys take the time, either side, take the time to write something and file it, I like to read it. And I haven't read it, and I
appreciate it.
I'm really at a loss without knowing. So we'll need probation up here if we get to that point. But in any event, we'll circle back. I don't want to start on something that. Let's just start looking forward instead of back.
I love the idea, Your Honor.
We'll do that. So in any event, all right, so let's talk about legal and evidentiary issues, and just in the sense of deadlines. What I would like is a joint witness list. Actually, I'd like a joint witness list because what I intend to do is treat this case like any other criminal case I preside over, and that is there will be individual voir dire, there will be attorney-conducted voir dire, and there will be a questionnaire. That's kind of my standard procedure. I won't make you try the case in front of me, but I know your staff has, so.
I have.
Oh, you have?
Yes.
Oh, okay. All right. So
I guess
you must have done such a good job that I don't remember. But in any event, so.
that's the thing too, is like, I guess there's word that maybe they had been having issues, but like, is there really anything on camera, or has family spoken out about them being in this toxic relationship? No. Like, as far as she was concerned, she didn't know she was going to get slapped with this restraining order. It came unexpectedly to her. So, yeah, I'm sure there's stuff we don't know about, but
That's where we're going.
it's wild.
So the reason why I bring that up.
And I feel like it's like, okay, if you have a habit, say a homeless man, it like has a habit of peeing like on buildings or cars, right? And whatever, can that be a crime? Maybe. And then he gets charged for like firearms. And it's like, wait, what does pissing on buildings and people have to do with firearms? Like, I feel like this is what this case is. I'm like, I'm shocked still about the alcohol monitor, because I can speak from experience, but I'm like, wait, again, why was she in jail? Because she failed to breathe into the breathalyzer or blow into it. And I'm like, I'm still just stuck on that. Maybe I missed something, because I'm like, why, because if that wasn't the issue, why would she need a breathalyzer? She didn't have the breathalyzer. We wouldn't be here, like at these hearings and stuff, for the breathalyzer and bail. Maybe for the firearm and whether she meant to shoot her coworker or not, but like, what? Yeah, Judge Alien filed the order without her. Justin, yeah, he filed. She didn't know what was coming.
Is because one of the questions that will be on that case-specific juror questionnaire will be, do you know any of these potential witnesses? And what I like to do is just attach some Word document or something that has both of your witness lists, both of your witnesses on, both sides' witnesses on there. Also, on there, we should list, the way it will be phrased is it will be potential witnesses and anyone possibly associated with the case. So if there's names of folks that their names may be prominent during the trial, some business may be prominent, I have no idea. Just things of that nature.
I'm so glad people on X are coming for him too. Like people are coming for him. I might have to join in and be part of it respectfully.
Should be just
I
the
might
mechanism to
have
do
to
that is
join
put
in.
them on this, potential witness list so that folks can flag it in their answer to the questionnaire. All right, so that's, and then also, frankly, I need to see a witness list sooner than later to make sure that I don't have any conflicts as well. And while I'm thinking of it, I will say this: it's not a conflict in my view, but I will raise. I did see in the file. I thought I saw a report from Dr. Zeisel, and was that on the defense side, right? Because you're
Yes, sir, we have him.
Before, right?
And that name didn't sound familiar.
No, okay. So I don't know if he's going to be a trial witness or not, but I will tell you, folks. Mr. 𝗝𝗲𝗍𝗶𝗆 may know this. I don't know. I used him a lot when I was a defense attorney. I've been on the bench 8.5 years, and I don't know if he's testified before me. I did keep in touch with him professionally for the first. It felt like the first year or two I was on the.
Yes, this is the new judge. This is we don't know if we like him yet, but we did not like the other judge. Who was it? I don't remember the name. We can see that on the previous slides. They did loosen the conditions a little bit, so
Bench.
I guess that's a
Just
plus.
because
Not really,
I still
no.
had cases. There were still cases pending that I had been counsel on. But I don't believe I've spoken to him in 7 years or something. But I did want to disclose that.
McCarthy, Judge McCarthy, dirty judge, they claim.
Again, I don't see a conflict at all.
Conflict
but,
of interest.
You folks can think about it. And do you expect that he'd be a witness?
So Judge, we're sort of on the fence about it, actually. That's the number one area that we're on the fence about. But if you don't have a problem with it, we certainly don't have a problem with it.
Yeah, I don't, but you folks will let me know. So on the legal evidence, what motions, what unusual trial motions should I expect, if any?
She's actually really pretty. She could have done way better, in my opinion, but
I don't think there are really any unusual ones, like bad act motions, things like that.
Yeah.
Nothing unusual from the Commonwealth side.
yes, Kat Randall. Her name was McCarthy, right? McCarthy Neiman. I don't remember her first name though. I think.
With the caveat that I don't know who their witnesses are or whether they're going to be calling us an expert. And that's one of the things I think we need to address today. So.
Oh, okay, yeah. That is a good point. So, because if there's going to be a mental health defense, so I want to keep this case on target for March 23 because.
Yeah, there's gonna be a mental health defense, sir. What do you think? Did you even look over this?
Agreed.
From my perspective, and I'm sure everyone agrees, if it's not March 23, then that's the to the extent that the case is assigned to me, and I don't know if that's been formally done or not done, then I'll be off to a civil session for 3 months, and we'll be waiting. So we've cleared the deck, so to speak, for March 23. So I'd like to make sure that we're on target to do that. But things like mental health defense could slow things up if the Commonwealth wants to hire their own expert, et cetera. So
I understand, right. So I think the Commonwealth has Rule 14 problems, though. They've got to comply with Rule 14 before we have to do anything. And I have a list of, and I know Commonwealth's been trying to kind of work with me, without bothering the court, which is always the best way to go on these things. And, we're sort of getting there, but it's going very slow. And I have a list of about 8 things here that, make their certificate of final discovery compliance really not accurate.
So can I ask, I thought I did see, Mr. 𝗝𝗲𝗍𝗶𝗆, from your perspective, is it the Commonwealth's position that you've folks have complied or are there still outstanding discovery issues?
I think the only outstanding discovery issue, and I did reply to defendant's request for his 8 items the other day. I hope he got my reply. It is the ones that we're going to talk about this afternoon.
Okay.
So other than that, there is maybe an issue with I have to provide him with
I'm still over here so mad that he's not going to get charged. What?
a link to something. But other than that,
Okay. All right. Well, I'll tell you what. I will put it on the agenda. Let's get right to it. What are the discovery issues?
So Judge, today,
And did you say that there was a certificate of compliance filed? Because I should.
the last date, Judge, right, and
You know, Mr. Quinn, do you have any idea what? I'm sorry, 50? I'll just get that out. Just. Fine. Okay. Go ahead, Mr. Brio.
Thank you, Your Honor. So Judge, today, the Commonwealth is giving me a surveillance system that was taken out of the house. So I appreciate that. We've been looking for that. There's some video.
What do you mean?
So
They produced
the actual, they took the actual system, right? And we need it for some other cases as well. And we've gotten that taken care of today. The Commonwealth's going to give me that system today. Expert notice. Okay. So under Rule 14, you know, I don't think we have the proper expert notice in terms of the CV and who's testifying as an expert and what's the opinion going to be. I don't know, you know, I don't know that I have everything or on that. And I'll elaborate on that a little bit as well.
Okay, well, let's just take them one at a time.
Sure.
So, what kind of experts would there be unless there was a mental health defense? You're talking about like ballistics or
yes,
something?
it's ballistics.
Okay.
I turned over the CV to defense counsel. It's on Axon. He has a report of the ballistician.
I can't wait to see this trial. I hope that she gets found not guilty, man.
Analyzed,
Like, because if
guns and
that happens, I'm sure maybe then the changes with her ex would probably change.
that one gun matches the shell casings that were found on the scene. Other than that, I don't see any other.
But this isn't, the defendant's not charged with a firearm offense, right? It's ADW, is that?
So here's where I'm going with this, Judge. We're sort of talking about 2 separate things. The Commonwealth has given us a 7-page report, and the report concerns the guns that the responding officers had. It lists 3 Glocks, and they're all the service weapons of the responding officers.
Okay.
So that's great. I'm not interested.
No, that's incorrect. And if defendant, I sent an email to him, February 6th, because we had talked about this. I hate to interrupt, but he's just wasting his time.
Yeah, go ahead. I'd like to hear it. Go ahead.
And in the email, I talked about which gun was which gun. There was 2 officers who were on the scene. One, the shooter, one Officer Noonan, who discharged his firearm, another officer who did not discharge his firearm, and the gun that the defendant is alleged to have. Yes, who is alleged to have. And that was her service weapon. And I detailed for that to defense counsel. And so the analysis that was done on the gun that was involved in the shooting. So that's all.
So this would have been, what was the officer's name? Noonan. This would have been Officer Noonan's service weapon.
Yes, and so I had sent an email because we had been talking about that on February 6th concerning that exact issue to clarify for defense counsel.
Okay.
So
Yep, go ahead.
I appreciate counsel interjecting with that. And if it's, I'll go back and look at it, but I read it to be the 3 officers that were at the scene and that their guns were taken pursuant to protocol. But if the Commonwealth is saying that that's the gun that was used, then that's fine. And I'm satisfied with that. I didn't read it that way, but if that's how the Commonwealth has it, I'll go back and look at it, and that's fine. So that's we can take that one off the list.
Okay.
Body-worn cameras, Your Honor. There were an officer visited Ms. Fitzsimmons early on when she was at Mass General Hospital. She spent 53 days at Mass General. An officer visited her there. And I don't know if there's a report that emanated from that or a body camera that emanated from that. And then,
So when you say body camera footage, it's very narrow, you're saying? Like
Right.
there's a specific event or?
right, it was one officer that visited her at the hospital, right?
Okay, and was this a social visit or something
That's a good question. It might have been half and half. I'm not sure.
And, would this have been?
Yeah, well, too bad they don't wear body cams. So, like, are we supposed to know the truth, Your Honor?
A North Andover officer?
Yes.
State police, okay.
Yes,
So,
Your Honor.
and have you told the Commonwealth the identity of the officer and the service?
It actually might be a trooper. If I could just have one moment. Detective Dan Furman.
Right, and who is that?
So he visited Ms. Fitzsimmons at the hospital, and if there's any,
I'm sorry, I meant, when I said who is that, I meant, what police agency?
so there's a visit from someone who's might be a social visit or a police visit. I don't know what it is, but I'd like to know if there's any.
Wow.
documentation.
All right, so this, but again, this person's name, this officer, detective's name?
Furman, F-U-H-R-M-A-N.
Okay, and what police agency does he work for?
People visiting her in jail too from her work? I hope not.
North Andover.
So this should be, well, and you're saying that you don't know if
Hossein, I think she's 28 at the time. She might be turning 29 soon, if not already.
it was a social visit or not?
All I know is the North Andover police officer visited her, and is there any documentation of it, or is there a report? Is there a text message from it? Is there anything from it? I just want to know.
I'm not expecting any answers right now. I'm just, do you want to weigh in on this?
No, this is the first I've heard of it, and I don't think the defendant would know if it was a social visit or anything more than that. I don't believe North Andover has body-worn cameras, but I will certainly make an inquiry. This is the first I've heard of that. So.
All right.
And then there's also office wanting to move the case along and get her arraigned. And there should be body camera from the state police from that.
All right, so is it?
And I believe that's true for strong.
Is this request, are you familiar with this?
With my understanding that defense counsel called me and asked that there not be body-worn camera when the state police went to her. So, but I will double check that. So.
Okay.
Wow.
My client tells me that there was body-worn camera that was activated, and that she was informed that there was body-worn camera.
Okay, well, if there was, then it sounds like it wouldn't have been North Andover, so.
No, that's state police.
State police,
That's
trooper strong.
is here today. I'll ask him.
Okay. All right, and you know what, excellent, because if the troopers here, to the extent that we can put any.
Yeah, Kat Randa, I see your comment. You said her baby just turned 1 and was not allowed to be at the first birthday in the Christian. What is, like, I don't get what proves she's unstable, that this whole incident happened. Like, why are they defending and backing Justin so much? Like,
These issues to bed today, that would be great. So what else?
Promises, rewards, inducements, Your Honor. That's the subject of an entire filing today.
Okay. So we will, do you want to do that now, or do you want?
yeah, true crime. That's why I was like, because when I knew it was someone from the North Andover police that visited her, yeah, why would you send someone after they just, like, asking a question while she was out of her mind? Because she got postpartum. Like, what did she even do? I know. What she did is she tried to unalive herself. So I could see where that can be like a danger to herself or her child, but really, like, I don't think so. I don't know exactly what his proof was, but since he was breaking into his computer, her computer, but I don't know. I thought getting a restraining order is like hard and taking custody. I don't know what the logistics are behind that, but it seems like you would need a lot of proof for that kind of stuff. But
What else is?
apparently
what
not.
else is on your
Apparently not in Massachusetts. So
list? We'll circle back.
That's the list, Your Honor.
Okay. All right, but I want to make sure I'm not missing anything, because didn't you say that you had 8 things and I only had 4?
So I'd like a witness list from the Commonwealth. I'd like to move to strike the certificate of discovery compliance to the extent that it triggers our obligations when their discovery obligations are not satisfied.
No, we don't. That's right. She became suicidal when they served her the restraining order. So I don't exactly know why they were taking the baby though. Like what is the initial problem, right? Because they went there to take the baby, give her a restraining order. So obviously there had to have been some lead up. Was police involved before? Is there videos of them putting hands on each other? Is there videos of maybe her threatening, danger to the baby that he has? Like nope, all he did was file a motion without her knowledge. Wow.
And by the way, Attorney Coakley, I don't have these rules about, I have a case in front of me now where there's 3 DAs and three assistant DAs and 1 defense attorney. They're all welcome to speak. So to the extent that I'm not, I don't have rules against more than 1 attorney speaking. So
I appreciate that, Your Honor. I'm not afraid to speak.
I know you're not afraid at all. I don't want you to anyone to think that to the extent that you want to be heard, you can be heard.
Thank you. I appreciate that.
What else?
Judge, there's also some OneDrive links that I know that I think the council referred to that. There's some OneDrive links for some discovery that we don't have. That we got some Axon discovery that had OneDrive links in it, and it was not communicating very well with our computer. So council is going to get me OneDrive links for, I believe, you said one more. So I'm actually at a loss to say what's on these OneDrive links because I can't open them.
Okay, all right. Well, that's Mr. Because do you know anything about it?
Yeah, as I had said just a few minutes ago, I understand what he's looking for. I understand, and we'll send him the link on Monday.
Okay. All right. What else?
I believe there were some redactions in the grand jury minutes that were given, Your Honor. And if there are any redacted grand jury minutes, we need the unredacted grand jury minutes.
I've never heard of that. But
Right, I think, yeah, it was strange.
No, and I tried to explain this to Howard when he got a redacted exhibit that I used in grand jury. And it was an interview with some of the officers that talked about things that I thought were too prejudicial to the defendant. And so I submitted to the grand jury for their consideration the redacted exhibits.
Okay.
However, he has the full exhibit also, meaning a full unredacted version of those recordings.
Okay.
So the grand jury minutes themselves, I'm sorry to interrupt,
No, no.
are not redacted. So.
Okay. If I have it, I'd like to have it.
Yep.
Okay.
So, yeah, I mean, it sounds as though Mr. 𝗮𝗄𝗆𝗆 has produced them, and I'm sure will, if not.
Okay, so why didn't he produce them appropriately or correctly?
Redacted and the unredacted
Like-
version, so you'll have a.
This is so frustrating. Wow. I think she would have been afforded rights to her baby when they went to court because it was. Oh, the shooting happened and caused a family court delay.
What exactly the grand jury saw, if you don't already.
Thank you.
What else?
The rest is the promises, rewards, inducements motion, Your Honor. There's 2 pieces here that are.
All right, so we're ready to go
Yes.
to the motion. All right, so let me just cue that up. Where's my notes? So it's been docketed as paper 53, defendant's motion for disclosure of promises, rewards, and inducements. And I have read it. I've read the attachments, and I don't know if this is an issue for Mr. 𝗮𝗄𝗆𝗆 or not. But I'll say that the problem that I saw with the motion is that it's not supported by affidavit. And I don't know, again, if that's something that the Commonwealth would raises or not, but to the extent that that you're relying on statements of your client and your client's father, I typically would see that in an affidavit form. Is that it?
Well, Judge, I do have an attorney's affidavit, and I do at the end of the motion, but I do view it more as like what we're doing here from the defense side is we're pointing the Commonwealth to specific exculpatory evidence.
Right.
So, how far we have to go with affirmative, averments of that, I don't think it's not like a motion to suppress where we're asking for the court to, make significant rulings. This is a notice to the government that says, hey, look at all this stuff that has happened. And, you need to figure this out. And I think that the government, in this case, with respect to this Elaine guy, has rose-colored glasses on where they're like, they don't want this guy to be harmed. They think this is a probate court issue. They think this is, just focus on Kelsey. Let's not worry about this guy. Don't look over here. Don't look behind the curtain. So this is an incredibly egregious thing this guy did. Ms. Fitzsimmons.
Yes, it is egregious.
In the hospital fighting for her life. That was her home. He had gone and gotten a restraining order in which he swore in the affidavit, I don't live there. I live in Stowe with my parents. He's now a plaintiff against Ms. Fitzsimmons as a defendant in a restraining order matter. He has no rights to that house whatsoever. 3 days later, her dad, who's a security expert and owns a security business, changed the locks, updated the security system, made his daughter's home secure again after this thing happened to her.
And after the shooting.
After the shooting, and she's in the hospital. She's away from her house. And this guy takes advantage of that to commit all sorts of serious crimes. He's on video breaking into the place with 3 other friends, 3 other accomplices, bust down the door, come in, it's on video, it's in an exhibit that you have, and he commits all sorts of serious crimes. The most serious one for purposes of this case is that he stole evidence. He stole evidence off the refrigerator. It's a felony. He had just.
Can I ask you something?
Yes.
Wow.
Everything that you say is true. The motion is for promises, inducements, or rewards. So your theory is what? That the Commonwealth promised to not charge this guy or something?
Yes.
Wow.
Yes. That's exactly what we think. And he's a precipient witness. He's at the scene of this shooting, Your Honor. He's at the scene of the shooting. This isn't about, 3 days earlier he did this order. It's that he's a precipient witness at the shooting. He's there. He and his sister are there.
At the end of the day, the motion is for promises, inducements, or rewards. So
Yes.
As those terms are understood, has the Commonwealth made any of those or offered any of that to this gentleman?
I think I can answer it this way. Okay.
Wow.
As far as him being a recipient witness, and you don't know very little about this case, the 2 people who were there in the room when the shooting occurred, when the allegations against the defendant pointing the gun at Officer Noonan and pulling the trigger, and him shooting her in self-defense, the 2 of them were up there. That's in the top floor bedroom. Mr. Alien was in the basement at the time of the house.
So he was there. What was he doing there?
He's on surveillance.
He's not a cop.
Video in the basement. He hears it, he leaves. So he's not a recipient witness. I'd just like to put this out there. That the case does not rise and fall on him. He might be a background witness. He heard the shots, but as far as what happened in the bedroom, he has no idea. So to say he's a critical recipient witness, I would suggest is a little misleading.
So, but
Now-
whether he's critical or not, there's either.
And I agree.
Okay.
And but I just have to correct the record.
Wow.
Now, defense counsel sent my office office a packet of information, including, and we have the video of, oh no, we didn't have the video. He sent video of Mr. Ali.
Like people who are outraged with Karen Reed, they should be outraged with this too. This is fucked up.
I'm going to call him Justin. I apologize. I'm having trouble with his name. Entering the house on a specific day. And the Commonwealth, and what is omitted from the defendant's argument, and he has this, and he knows that the day before this happened.
And it's beyond that, not just Karen Reed. It sets a precedent that like your ex can break into your house and do all of this shit.
Justin called the North Andover police and asked if he could enter the apartment. He told them that the defendant was on the deed, but he had property there. And they told him he could go in. On the next day, where this video is, he calls again and says, I need to go into the apartment to get my stuff. He asked for a police escort because he's afraid of what the defendant and the defendant's family would do.
Oh my God.
He was worried about his, in his words, vengeance.
Oh, now he's worried about that.
Okay. And so he does.
But not when he was saying and writing that she was a great mother. Makes real sense. Yeah.
He does push the door open. He goes in to retrieve his items.
With the police escort?
No, the police didn't come. At that point, the alarm went off because I'm assuming there was some surveillance video in there and an alarm system.
Sure.
When the alarm goes off, he calls the police and he says, can you come here, please? The alarm went off. I'm worried that the family of the defendant will come, and I'm worried what will happen because they're very vengeful about the whole situation.
Okay.
And they said, we're not coming, but if he shows up, let us know and we'll come and keep the peace. He then gathers his belongings and left.
Okay.
So we can't look at a crime. The Commonwealth, in any case, does not look at a crime in isolation. We have to make determinations when we're looking at cases, okay? Justin has also filed an affidavit report.
In this court or in the?
No, in the probate court, as the restraining order, which 3 judges have.
Ew, that baby should not be with his father because his father is shady.
Not been found credible. And the defendant has yet to litigate that motion. And so we have information from the defense about what happened, about this breaking and entering and this supposed theft of evidence, and that's the first I heard of it was evidence. And we had that packet. We reviewed it in an abundance of caution. We asked Middlesex to look at it, and they were going to take a look at it. At that point, Attorney Coakley called Middlesex, the first assistant, about that. Middlesex then called us and said, we can't do it. We don't want to take a look at it. We think we have a conflict now. So our office then looked at it, and we determined that we are not going to charge Mr. Alien for these crimes.
We're not going to charge him with the crimes of breaking in, taking her laptop, taking her money, getting her records, changing her passwords. I can't do this.
I don't know if he even knows.
I might have a baby heart
that this is out
attack.
there. I don't know if he even understands that there are charges
What?
that the defendant is alleging occurred. I haven't talked to him about that. If I do,
No, I can't. Just made it seem like he was getting his things and stole her stuff. Parental alienation is a real thing. I would be terrified if I was Miss Fitzsimmons. I'm screaming.
has a concern, I'll tell him that we're not charging him with that based on the entire circumstances of this case. The Commonwealth is often in the position of analyzing cases when there are dueling issues and dueling statements. And we have an obligation to parse those out. And if we don't believe there's probable cause, we don't charge. That's what we have here. The Commonwealth has made the determination not in isolation, but in the whole circumstances of this case, that we are not going to charge him. If at some point during the case, Your Honor thinks he has a fifth, we'll immunize him. But we haven't told him that. Defense counsel is now on notice that that is our position. So is it a promise of ward and inducement? It is what it is right now.
Okay.
So they're on notice of that.
All right, so, Mr. Bradel.
Yes.
Let me see this. So the whole idea of the, of discovery, obviously disclosure, it sounds like perhaps this is the first time that you've heard the full version from the Commonwealth's perspective, but to the extent, now probably isn't the time to determine whether it's a promise, inducement, or reward. I think now is the time to determine the sufficiency of, assuming that it is one of those three things, the sufficiency of the notice provided.
Absolutely, that's what we're interested in, Judge.
All right, so,
Communications.
all right, so it sounds as though, so what,
I think the DA for Essex County is Tucker, right? Alien. His name is Justin 𝗲𝗏𝗍𝗲 or something. So we call him Alien, I think. He said he calls someone, he just said he calls up someone to look at the case because he had a conflict. Then when other people had a conflict, he decided to look at himself after just stating he had a conflict. This is crazy.
so what is it?
I'm outraged.
That you're looking for? Do you want something in writing that they're not gonna?
So just a couple of quick things, Judge, as far as your comment said. I have the call that he made to North Andover to one of the sergeants up there, I believe Sergeant 𝗏𝗏𝗆𝗏. I mean,
I don't know who the DA. Good question. Is it Morrissey? You might be right. I'll look it up.
Anyway, but we have the call, and in the call, he's committing another felony called misleading police. He's saying to her that he still lives there and that he wants to get in there, and he's looking for a dispensation from them to let him get in there. And he lies to her, and he says that he still lives there. Completely contradicts what he already swore to the probate court judge, family court judge, to get the restraining order. And so the sergeant,
Yeah, it is.
I think, does the right thing and says, well,
Essex County DA is Paul F. Tucker.
if you have a key, or, if that's your house, I can't stop you from going in your house. But she doesn't say, yeah, you go right ahead and go in the house. She's deflecting and saying, well, you're telling me you live there, I can't do anything about it. So it's this sort of round and round conversation where he's trying to get dispensation from them, and she wisely just says, well, if it's your house, go ahead, but I don't have anything to do with it. That to me is the gist of the conversation that I have. So there's yet another crime that they're looking the other way on for this guy. But in any event,
Mr. Bradel,
so I'm sorry, I'll tell you what I'm looking for, right?
Yes, please.
All right, I'm sorry. So I'm looking for text messages, emails, notes to, what is the police, what is the DA's office, what are they saying about this incident that they know about? Are they saying, don't worry about it, we're not going to prosecute you? I want the communications. What are they saying? I can't, it's always hard from a defense perspective to, guess what's out there. They should be giving me, here's all the communications about Elaine and him breaking into the house and why we're not prosecuting him. And this whole business about that, he checked with the police, he lied to the police. So he didn't check with the police. So their facts are all wrong. And, he should be prosecuted, and they're in a conflict of interest, and the court should direct them to appoint a special prosecutor because they clearly have a conflict of interest in trying to prop this guy up for their own case. And so they ought to be ordered by the court as a matter of ethics, as a matter of appropriate behavior as an attorney to appoint a special prosecutor. And I want to ask the court to take a serious look at that.
Oh my God, this is crazy.
Let's do this. Can you, and can Ms. Fitzsimmons as well, come on over to sidebar for a moment.
Oh, that noise sounds terrible. Oh, is that it? I guess that was it. That's all I have on that stream, which is fine. He's right. They have a duty to produce it. So didn't they stipulate he broke into the house? It looks like breaking into me, guys, on the video. Like common sense. It looks like he broke in. I want to play this 1-minute clip. Wow.
Who was shot in her home by fellow officers are now making new claims about her fiancé. Kelsey Fitzsimmons' lawyers filed this video in court yesterday. Lawyers say it shows her fiancé and other men breaking into her house 3 days following the shooting. They claim he stole cash, gift cards, and Fitzsimmons' laptop, which they say he used to withdraw $5,000 from her bank accounts. Lawyers say they then turned the evidence over to prosecutors back in August, but their request to appoint a special prosecutor to look into the video was denied. Fitzsimmons is accused of pointing a gun at officers when they tried to serve her a restraining order last summer. Fitzsimmons accused her of threatening him and their newborn. Her lawyers say that she was suffering from postpartum depression and is getting treatment. She's currently in a custody battle with her fiancé. She is facing one charge of assault with a dangerousness weapon and is set to go on trial next month.
Wow. PZ, good to see you. Miss you too. Any potential exculpatory or relevant information should be produced. Common sense isn't so common anymore. He totally set her up, didn't he? Yes, he did. I truly believe that. Yes, he did. I'm so outraged for her. No, obviously they're not engaged. Ugh. I can't believe it's already going to trial too. Well, it's been a while. But I guess just with everything going on with the custody battle, I bet that's all going to be placed on hold until this gets resolved. Justice for Kelsey Fitzsimmons, yo. Crazy case. Hadn't done an update in a while. I did add it to the playlist. There is a Kelsey Fitzsimmons playlist. I think it has like maybe 4 videos on there. Go check it out. Get caught up on the case. I don't know how long trial's supposed to be. I don't think it's supposed to be very long, but we probably most likely will be covering it if it is live streamed. If it's only, I feel like it shouldn't be very long, but we'll see. We'll see. I'm beyond sad for her. Justin thought she was going to die and nobody would find that he stole her money. I know. He did. He thought she was going to die. Because like, why else would you do all of that? If you knew there was a video of him breaking in too. He must have known or assumed. Thank you, Lakeside, for being a member for 5 months. I appreciate you. Thank you for the live stream. Yeah, I know Kelsey's not like a super big case on my channel, but I do stand by, the mental health thing and against corruption. I never heard of this case. Really? You've never been here when we covered it before? I've covered it quite a few times. So sad. Anyways, we'll see what happens. Trial starts 23rd. I'll definitely keep you guys updated. He was going to take her out. No, I think he thought she wasn't going to survive from the other cop shooting her. Yeah, I have a playlist on this. I've been covering it, I think, since the beginning. So definitely check out the playlist. We've read a few court documents, and I think we played the last hearing as well. So yeah, I've been covering it here. It's just been a while because there hasn't really been too much to cover. How did I miss it? Go back and replay the playlist. Okay, politics or Corey Richards tonight? You guys didn't tell me. Some of you said Corey. Sorry, I cheated on you. And watched somewhere else too. Ugh, Cat. Well, I haven't been on this like every single day, so I could see why, but don't be cheating on me. Corey Richins, politics, hangout, all of the above. I don't know. Keep your eye out. I'll be back in a little bit with another live. I wanted to do a Corey Richins marathon tonight, and then I also do want to cover the war that's going on, but we don't do politics here, so I'm not sure. And I also do kind of feel like maybe some buzzballs. I don't know. Corey, okay. I feel sorry for her. She probably feels like she cannot win. I'm eager to see what happens. Yeah, I kind of want to get caught up on Corey too before Monday. I don't want to get deeper into the trial without getting caught up. So I believe it's already scheduled. It is. I'll see you there. Tap the like button on the way out, Corey. Okay. I'm down for Corey. I'm behind a few days, so I'm down to get caught up. Tap the like button on the way out, guys. I will be back to give you updates on Kelsey Fitzsimmons' case as we go. A shout out to you guys for being here. I appreciate it. Keep your notifications on, hit that like button, and I will catch you on the next live. Toodles.